Hello and good afternoon, everybody. Welcome. We're happy that you're here. Thank you for joining us this afternoon. My name is Angela Brewer. This is Rick Giesecke. I'm the manager and deputy administrator of the Community Corrections Department, and on behalf of all of our staff who are joining us as well and will introduce themselves shortly, and the Community Corrections Advisory Board, we'd like to welcome you here to our presentation as we take a walk with you through probation in our county and give you a little bit of information about what it is that we do, all of the different ways that we work with justice-involved individuals, and what that means for you as our system partners and community members. So as we go through the presentation, our staff will introduce themselves and they will share about information from the stations that they're at. But before we get started, just wanted to give a little bit of foundation about our department and community corrections and probation in general in Minnesota. Minnesota is one of the states in the nation with the lowest incarceration rates, so a number of people in jail and prison. And what that also means then on the reverse side is we are one of the states with one of the highest numbers of justice-involved individuals on community supervision. In the state of Minnesota, 87% of the people who are involved in the criminal justice system are on some form of community supervision, either pretrial, probation, or supervised release. So that is a very large amount of people. But what that also means is that the work that all of these individuals do in the probation department and community supervision has a large impact on the lives of justice-involved people and on the communities that we serve. So the work that they do is very important. It's done with a large group of individuals, and so it's important to be targeting the right work with the right people. And we in community corrections are committed to using evidence-based programming and practices with individuals because those are programs and interventions that evidence has shown is impactful, that make a difference in improving lives, changing behavior, and helping people to make more pro-social decisions, which end result of that is a safer community for everyone, including all of the people who live or work in our communities. And so the work that they do is extremely important. As you can see from all of the different stations that we have, there's a lot of different intervention opportunities and a lot of places where our staff interact with individuals as they move through the criminal justice system. The way that we've designed this presentation is we will be walking through the experience that a person in the justice system would have with our department in the order that a person might experience it. Not everyone who goes through the criminal justice system will experience all of these different stations, but they are designed in a way that walks you through preventative efforts before a person meets us, and then what happens after someone maybe is arrested or detained and goes to court, and we walk you through the process from there. I would like to turn it over to our staff at the community-based coordinator station.
Well, I'm Dylan Harvey. I'm a community-based coordinator out of the Northfield Police Department. I do have a couple other co-workers. I'll let them introduce themselves.
I'm Ruth Langen. I'm the community-based coordinator for the Faribault Police Department.
Cindy Salvick, community-based coordinator for the Sheriff's Department, and most of my work is done in the jail.
Okay. And so what a community-based coordinator is we're sort of a social work-based type worker who is embedded in the police departments. And what we do is we assist the police in interacting with individuals who come into contact with law enforcement, either through their mental health or chemical health needs. And we assist and reach out to them and offer them any sort of services that are available in Rice County. It is a voluntary-based program, and anything else to add? So,
right, it's a lot of the people that we deal with, or some of the people we deal with, are frequent flyers of the police department that they get multiple calls from and they're not really able to help. It's not really a criminal matter. Most of it, like Dylan said, is mental health or chemical health. And our goal is to try to help them get hooked up with long-term services.
And another thing though, some of the types of calls we assist with, which you may not be able to see on the board here, the individuals that are either in crisis, either mental health or chemical health, as well as overdoses and things of that sort. We either connect with the individuals directly involved or the family members that may be in need of assistance that the county can provide. And Cindy, what's going on with the jail?
Well, if people do end up in jail, for the past 4 years I've been doing this. I go in early in the morning and talk to people who have been booked into jail overnight. I do a short screening with them looking for mental health and substance abuse issues. That's the main goal. And about 95% of the people in jail also have, really their biggest problem is substance use. So I spend most of my 40 hours a week with getting people lined up to get assessments for treatment, getting them a bed, coordinating that. A lot of people in Rice County get furloughs from the judge, which means they can leave jail to go to a treatment program. So I'm coordinating that. If they leave the program, if they're not successful, or if they choose to leave, they have to return to jail. But most of my time is spent coordinating treatment services for people.
Right. And I'd say, again, with reaching out to these folks, a lot of them can actually already be involved with Rice County Social Services as well. A lot of it is kind of partnering with either, be it adult mental health, child and family, kind of connecting with the services we do have and reaching out and seeing what sort of resources we can come together and sort of resolve or assist with these individuals' needs from a team basis. And with that, a lot of it is usually partnering with case managers at social services. Also, in a new program that just kind of rolled out March 1st, we have the PARD program, which is the Police Assisted Recovery. And what that does is also, the D stands for diversion. So folks who come into contact with law enforcement and maybe are having either, usually it's chemical health concerns, their substance use, they will reach out and they can just tell the officer, you know, hey, we need help, and there's this new program where we have grant funded and it pays for a sober housing bed for the person to stay. And then we will, as CBCs, meet with them the very next day and reach out and fill out applications and refer them to treatment. And sort of as a way, it kind of prevents them from having further interaction with law enforcement, and they can hopefully address their substance use prior to catching charges with law enforcement and moving further up the chain. And there's part of the diversion one, if they do actually end up being charged, it can be reviewed with the attorney and they can determine if they're eligible based off of certain criteria, if they can face diversion for the charge and attend treatment. And ultimately our goal is to prevent, on a voluntary basis, prevent people from moving further down the line to the next step.
All right, hello everyone, my name is Jackson Hansen. I am one of the supervisors here at Rice County Community Corrections. So I am going to give you just a brief summary on really the initial stage of when our office comes into contact with individuals from our community for the first time. So namely, we are at the arresting and jail booking process. So what that means is someone has committed either a felony level offense or an offense in which they would need to be seen before a judge to determine conditions of release. So an officer has arrested an individual and they have been booked into the Rice County Jail. So the Rice County Jail is, while we are not a part of the Rice County Jail, we regularly interact with them on a daily basis for various things. For purposes of this, someone has been arrested for the first time or for that particular instance, and they have been booked in. So what will happen next is, following the next business day, the correctional officers will create a list. Typically we refer to that as the in custody list or arraignment list. And what that is the next business day, we get this message, we get this email from the Rice County Jail letting us know who's been arrested, whether it be over the weekend or the previous night. And that'll tell us two things. It'll tell us who we need to interact with for either the pre-charge adult diversion or the bail process. So for purposes of this, we are going to go down the line and discuss, Shelley and Aaron will discuss the pre-charge adult diversion process.
I'm Shelley Marquardt, adult probation officer. Part of my caseload is the pre-charge adult diversion. I do treatment court, and until we transfer them off, I have traditional clients on my caseload as well. So, you want to introduce yourself and then I'll go?
My name's Aaron Osborne, also an agent taking on the pre-charge adult diversion caseload, also taking on treatment court as well on the side.
Okay, so pre-charge adult diversion is exactly what it says. We just got a grant, the county just got a grant, it's called the COSAP grant, and this grant is designed to keep first-time offender, no, they don't have any prior felonies on their record. They're offered, if they meet certain criteria, to take charge or to take part in the PSAD program, pre-charge adult diversion. Who qualifies? They can't have any previous felonies on their record. They have limited involvement. They may have some misdemeanors, gross misdemeanors, but none of them can be serious person offenses, domestic violence, DWIs, drug crimes that are first or second degree. They're all disqualified. So we find out who's qualified by when this jail list goes out, in custody list goes out every day. The county attorney and one of the assistants reviews that list, and then they email Aaron and I, as well as a couple other people, and tell us whether anybody on the list is eligible for the diversion program. It's a program that can last up to 24 months. That's the longest somebody can be on the pre-charge adult diversion. It's 100% voluntary, similar to what the CBCs were telling you about their services. They have to willingly want to do the PSAD, and there's no obligation. If they choose not to, then that's okay. Then they proceed through the rest of the process. If they successfully complete, there will never be any criminal charges filed on them on that case specifically. Once they complete the diversion, then the case is dismissed and it goes away. And it's definitely a collaborative program. There's a lot of different partnerships that go along with it that is going to make it successful. So far, this program just started March 1st, and as of right now, we've had one. So there's a lot of, the disqualifying things kick a lot of people out, but we expect that those numbers will increase as word gets out and we're able to get more people.
So when a person's booked into jail, we screen them then to see if they're eligible for the pre-charge adult diversion program. That is done by one of our partners, the county attorney's office. At that point, they complete the daily screen for the referrals. They then tell us about whether or not they are eligible. At that point, we go in and we do an intake with them. Now, it is again 100% voluntary, so we're going in, letting them know what their options are. They can either move forward with this program with us, or they can, have their time to fight the charge in court. Assuming they continue on with us, we complete the intake, and then they are assigned a recovery navigator. And this navigator is part of another partner of ours, Health Finders. The navigator then begins case management, coordinating services. They help them find support in other areas. If they need a pre-treatment bed, we have another partner, Beyond Brink, that we have several beds then saved through them. If they need a day or two to find a sober place to stay until we can get them into an actual inpatient bed, that's where they would go. And then from there on, Shelley and I are going to be working with them over the next up to 24 months. Coordinating services with a recovery navigator, and communicating with the attorney's office and our other partners to ensure that the participant is following through with all of the requirements. We have a list of several conditions then that we just came up with. Requires active participation. They're going to be treated as if they're on probation. So a lot of the interactions that are going to take place between Shelley and I are similar to what we'd have with a traditional client. They are required to participate, be respectful. If any of these conditions aren't followed, we then talk to the county attorney's office, who then would refer it on to further processing and then charges in court.
One thing I would say about that is one of the conditions of the PSAT is they have to fully admit guilt. So whatever offense that they were arrested for, or that the police have cited him for, so let's say that it's a possession of drugs, but they had meth on them. In order to take part in it, they have to admit that they had drugs on them. They can't just come in and say, well, no, I don't think that was mine, it was somebody else's. They have to accept responsibility for it. That goes into the document. They're saying that they accept responsibility. And if it were to come time where they didn't successfully complete this program and it was going to get referred back to the county attorney's office to prosecute, that statement of their guilt can be used against them in those further court hearings. But they do have to be accountable for it. They do have to admit that they did it. They do have to go to treatment, participate in a substance use treatment program, outpatient, inpatient, if that's what the assessment says. There are some hard and fast conditions that they don't have an option of whether they do or not. If they're going to be in the program, then those are parts of it.
So if during the screening process they are found not to be eligible for a pre-chargeable adult diversion program, they then move forward on to our bail process.
Hello, I'm Jennifer Sargent with Probation, my coworker.
Tori Barnett with Probation Traditional.
So we're going to discuss the bail evaluation today. So bail evaluations, we are actually mandated by the court to complete bail evaluations on certain offenses, serious felony offenses, and others that Minnesota deems crimes of violence. The reason we do these is to assist the court with obtaining information about the defendant. It's to give them impartial and unbiased information to assess overall risk and potential for showing up at future court hearings. How we do it is with the bail evaluation. So the bail evaluation is, we use the, it's a mouthful here, Minnesota Pretrial Release Evaluation and Assessment Form. We call it MNPAT for short. The MNPAT is actually a judicially approved form or tool and is used within 62 of the Minnesota counties. Rice County has completed roughly 330 of them in the year 2022. So how we do this is, like my coworker said, the jail sends out an in custody or an arraignment list every workday morning. We get that list and see who meets these criteria of the statute. We then go to the jail or the courthouse holding and interview the clients to obtain the special information that the MNPAT is requiring, such as the criminal records. We obtain the Minnesota Bureau of Criminal Apprehension criminal records and look through all those. Community ties and housing. Do they have family? Do they have children that they are supporting? How long have they lived at their current residence, or are they considered homeless? Are they employed? Are they full-time, part-time? Are they going to school? How much? The other thing is looking through previous warrants over the last 3 years. Any warrants for failure to appear. And then we touch on the use of substances, alcohol and controlled substances, including marijuana, and then any military service. And so we take all that and it gets incorporated into this report, gets scored, and we e-file it over to the courts and attorneys. Rice County does, or Probation doesn't have any say in the bail that's established or any of the conditions of release.
So, and as Jen was saying, we kind of made like a little flow chart to give a better understanding of which way it can go in court. So again, we're not making those recommendations on what the bail is. That's up to the judge and the courts and the parties to decide, if they're going to be released with conditions, if they'll be released unconditionally, or if they'll be held. So those are kind of the three options that we gave out. Unconditional bail is usually a monetary amount that's pretty high. You're not going to have any conditions with that. You're just paying that bail money, and then you're just appearing for your next court hearing. Unconditional bail doesn't mean that you just don't go through the court process at all. You still have to show up for that next one. Detention or being held without bail can be for a majority of reasons. The main one being that you're a high risk level after we've done this entire assessment. Maybe you have a lot of previous history, and maybe you have some substance use. Going along with the held without bail, kind of how the CBCs went over, there's also the opportunity to furlough. So kind of Cindy had touched on the opportunity to get into a treatment center, which she deals a lot with. Getting people into somewhere where their substance use can be addressed rather than sitting in and being held without bail. The most common one is being released with conditions. That can be a monetary amount or released on your own recognizance, which is $0. So to put it like that, if you're ROR'd or if you have a monetary condition, that condition is usually a little bit smaller than the unconditional because you're agreeing that you're going to abide by these conditions that the court puts in their release order. A lot of those can be remain law-abiding, no use or possession of any alcohol or substances, and then just maintaining all future court appearances. Going along with that, you can also have some supervising conditions, like alcohol monitoring, and that's when Sam would supervise, so she'll tell you a little bit about that.
So I'm Samantha Dahl. I'm a probation officer. I mainly do adult and a lot of the pretrial supervision. So if the judge does order you released with conditions, and one of those conditions is to check in with probation, with Rice County Probation, that's typically me, and for that, they would have to check in with me. Usually it's once a week, sometimes it's less, sometimes it's more. It depends on that specific need of the client along with what's going on in their life at that time. So during that time, they are also going through the court process. They're going through all the court proceedings. They're going to their next court date. I'm helping them remind them when their court date is, or they will call me, ask me, when is my next court date? I let them know. It's someone else to help hold them accountable that they go to court, that they follow through with other conditions that the judge orders, along with just having a face instead of this big scary thing that court can sometimes be for people. With that, it also can mean that they that they can have to do other things such as mental health assessments or chemical health assessments while their court hearing is pending, because the judge might want that. So I would give them resources in doing that. And the only way to be done with the pretrial supervision is, one, by the case still being pending and the judge changes your conditions of release. So the judge at your next court hearing or your attorney can always file and ask for your condition to be taken off, so that they have to check in with me, that be taken off for whatever the reason. Second way is that they are convicted of these charges or the case is dismissed. And then third way is, like I mentioned before, I guess, the second and third way, dismissal and conviction. Right now we do have 35 people on pretrial supervision. Those are not all with me. They are spread out through the other agents because of the fact that, again, court can be a big scary thing for some people. And if you are already on probation with somebody, it's much simpler for everybody involved if you stick with that one person. So for example, I might have 20 people, but then another person has someone else on probation. They're gonna take that other pretrial case. So it's simpler for everybody involved and that client doesn't get lost in the shuffle. If they do get pretrial and they end up pleading guilty for whatever this case is, they could be sentenced then to ordered to do a PSI, or pre-sentence investigation. At that point, then our office would be doing this interview with them. There's a nice little flow chart that you guys can't see because they're too far away, so feel free to scoot closer if you want to. And if they plead guilty, then they would set up an appointment with us to do that interview. That can be done in a couple of ways. We have done it by Zoom because of COVID and the pandemic, or because of transportation issues. We have done it by phone if someone is not very tech savvy. We have done it in person. We try to meet the client where they're at. And it's very important for us to get this information because this helps them be seen as an individual with their own needs, their own risk factors, that the court doesn't always see if they only go based off the complaint or the police report. So it's very important for the client to do this with us so that we can help determine what set of conditions we could recommend to the judge. And this could be a little bit different than what they might have pled guilty to and agreed to in the plea agreement. And a plea agreement is an agreement between the prosecutor and the client and their attorney to resolve the criminal case. The purpose of this is to settle the case short of going through with the trial. So there may be a set of conditions and expectations in that. When we do that PSI, we do a PSI report. In that report, it could be exactly the same as that plea bargain, that plea agreement, or it could be a little bit different because now we have more information. We go in depth with them. We talk about, we kind of do the funnel effect. So we talk about their criminal history. We then go into a little bit more personal, talk about employment, a little bit more personal. We talk about family, a little bit more personal. We talk about mental health and substance use. We kind of get down to that nitty-gritty part of it, and we hope that they're honest with us so that we can best serve their needs and address what's going on. With that being said, we also do assessments in the term of LSCMI, which long phrase, long acronym, basically means where are your risks in life, where are your needs, how can we merge these together and address them and have your probation officer help you with these. So we determine that helps us determine validated evidence-based practices that has helped us determine how often they should meet with us and what type of programming that might be beneficial for them where they're at. There are other types of assessments that are done during this pre-sentence investigation time when they're pending sentencing, and those include the mental health assessment, domestic abuse assessment, chemical health assessment, gambling assessment. These all are determined by the offense that's conducted and if the judge ordered it. There's some things that a judge may order that we might not have done at this step, but because of factors that the judge has known about, they may ask for that type of assessment to be done. Again, whole purpose of this big interview is so that we can get an individualized conditions set forth for this person and that there's a nice report for the prosecutor, their attorney, and the judge to see them more than just a case. They see them as a person. They see all these other factors that are going on in their life at that time. Right now, as of 2022, so numbers I guess won't change, we have done over 300 PSIs. So Rice County alone has done over 300. 216 of them were felonies alone. So we are very busy, and this is a lot of work to do this, and it's also very important, as you guys kind of heard me say. And if they do all of this, we do this report, it gets filed with court, and then they are sentenced.
Sorry, I'm Kim Hedenstrom. I'm a probation officer with Rice County. Right now, my caseload is predominantly high-risk domestic violence offenders. Okay, and I'm just going to touch briefly on the sentencing process. We do not have a lot of involvement in that. After we send the pre-sentence investigation over to the judges, we will be present at sentencing to see what happens. But I can note that sometimes we are not involved in a pre-sentence. A person can go in front of a judge and they can be sentenced without any sort of pre-sentence investigation, kind of based on the type of offense it is. And at that point in time, that might be the first time that they actually end up having to come into our department and work with us. When they are sentenced, some of them are sentenced to probation. Some are sentenced without probation. They might just get a fine. They might get jail time and credit for time served. They might get sentenced to probation with an alternative organization, such as Diversion Solutions, which sometimes addresses like a lower level offense, like a misdemeanor DWI, and they will have to report to them. But the cases that come to us are usually placed on probation for anything from a misdemeanor up to a felony. That can go from 1 to 5 years of probation. That's all determined by the judge. And so we make our recommendations in our PSIs. Prosecution make their recommendations. Defense attorneys make their recommendations. And so what happens is they will go in, they will be sentenced, and there'll be a list of conditions if they're placed on probation. Minnesota has, which again you can't see because it's far enough away, but there's a general list of conditions that Minnesota decided everyone who's placed on probation should have to follow these general conditions. So they will have general conditions, and then in addition to that, the judge will impose specific conditions that pertain more to the type of offense that they've committed and to the needs that we've determined need to be addressed based on our risk assessments. And so once they are done being sentenced, they will come over for intake, and I will allow Aaron to talk about that.
My name is Aaron Langer. Right now I have an adult domestic violence caseload. And once the person is sentenced, they do come over to our office to do an intake. They meet with a duty day intake probation officer, whoever's doing that day. It may not be the actual person that did the PSI, it could be, but most of the time it's not. At that point, we try to answer any questions that they might have from what happened in court, because sometimes there's a lot going on at courts. They have questions, we try to answer them the best we can. That is also the time that we go through the conditions that the court gave to them to explain, answer questions on those. We also do the general probation agreement, which is listed on here. Like I said, it's kind of small to see, but the general probation agreement for misdemeanor and gross misdemeanor and felony cases. But if they are convicted of a felony, there is a separate probation agreement specific to the felony cases that we would go through with them probably at one of their first regular meetings with their probation officer, because at that point we probably wouldn't have that completed. Also, during that intake, we look at helping them, or we go through other documents to have them sign them, including any kind of release of information forms we may need for other services. If they're in counseling, if they're in treatment, if they're doing those things, we need a release of information form to be able to talk to them. So we'll have them sign those. We'll also have them, we can also help make referrals. So if somebody has a chemical dependency assessment to complete, or a mental health evaluation to complete, or they have to do electronic home monitoring or alcohol monitoring, things like that, we would make referrals, give them information on where they can have those things completed to kind of help them start that process. If it's an electronic home monitoring type thing, we would have to do that referral to that monitoring company to get that condition started. So basically that process is just for them coming right over after court to help them kind of get things started at that point. That's all that meeting would be, and it doesn't take too overly long. At that appointment, more than likely they will know who their probation officer is going to be. We'll give them the information, we'll give them their card, and then let them know that that person will be in contact with them. And then that's where we move on to the next phase, which would be the different types of caseloads that they'd be placed on.
I'm Amy Young, and I have a split caseload between traditional caseload and then also people who are in for sex-related offenses.
Okay, so we've gotten to this point where the person has been sentenced, and from this point on, they're on probation. So they've been assigned to a caseload, and the one that Amy and I are going to talk to you about is what we call the traditional unit. So that would be any offense that isn't considered one of our specialized caseloads, which you're going to hear about after we're done talking. Aaron and Kim talked about the level of offense of people who get put on probation are felony, gross misdemeanor, and misdemeanor. The purpose of probation, number one, is public safety. Client accountability, right? Our goal is to have our clients be accountable for the choices that they made, the crimes that they committed. We want to restore victims to be fully again, so whether that's a financial, maybe that's an apology letter, maybe that's just them knowing what's going on with this client throughout this probation term. Our job obviously is to monitor the court-ordered conditions, those conditions that the court put forward. We don't get to decide which ones of those we enforce and which ones we don't. It's our job to monitor all of them. We assist with helping our clients find what needs to be changed and helping them make changes that would be positive. We want them to be positive, contributing members of society. And so one of our big goals is to walk alongside of them using all those risk assessments that you've already heard about to try and figure out what are the things that they need to work on first, what do they need to work on second, and how do we need to get there.
Okay.
Is it your turn?
I think so.
I'm more of a fly by the seat of my pants, but Amy is more of an out loud, and so this makes her comfortable, this makes me anxious.
And it's working still. So as was mentioned, we have a handful of different levels of offenses between felony, gross misdemeanor, and misdemeanor that we supervise. And so we have a graph up here, about 50% of our supervision is with felony-related offenses. About 35% is gross misdemeanors, and 15% are that misdemeanor caseload, or misdemeanor cases. We also, the traditional unit supervises a variety of different offense types. And so we also have that broken down on here, and then a list as well. And so majority of our cases supervised in the traditional unit will be drug-related, whether that's drug possession, drug sale. We'll also include driving-related offenses or alcohol-related offenses. Some of our other ones we supervise would include assaults or theft, fraud. It would include different property damage, weapons-related, burglary, robbery, things like that. So it is a really large unit that we, of cases that we supervise. And so, yeah, the graph is right up there. That breaks it down a little bit more.
Okay, so it was really hard to come up with everything that we do with all of these people. So we just kind of tried to group some of them together. One of our big things, you've heard this along the way as well, is we collaborate with community partners. If there's somebody out there who's already doing it or they would be a good fit to work with somebody, we refer those people to them. Whether it's Health Finders, Beyond Brink, substance use disorder, mental health therapy, domestic violence programming, individual therapy, any array of things, Hope Center, whatever we can refer them to that would be helpful to them, we do that. They often get their risk assessments at that pre-sentence investigation stage, but those risk assessments need to be updated every 6 months, every 12 months, something like that. We're updating those all the time because that's what we're using to determine what is the highest priority to work on right now. So those are something that we do often. We really want to coach our clients and help them figure out what's important to them to change, right? Any of us are the same way. If you tell me what I need to change, I'm more likely not to want to change it, but if I decide I want to do it, then I am more bought into it. So we are trying to help them figure those things out and maybe prod them along a little bit through a series of different things to get them to decide what is best to be worked on and why it would be good for them to be working on it.
Perfect. Another bulk of our time is spent meeting with clients. So that would include, we meet with clients in the office frequently, but we also are often in the community and making contacts at their homes. We also will meet with them at treatment centers or sober homes. We try and meet them where they're at, as transportation can sometimes be a barrier. So that could include coffee shops, local police stations, parks, different areas to try and meet them as often as possible. We will also spend a lot of time completing reports as needed. That could include court reports that you just heard about with the pre-sentence investigations, probation violations, which you're going to hear about a little bit later. It would also include attending court hearings or testifying as needed. And in general, we just really, a lot of our time is spent collaborating with both our clients and partners.
I had mentioned that one of our purposes is victim restoration. So with that comes victim contacts. And maybe there are some victims who want to have contact along the whole way. There are some that want very minimal contact. So it's really about trying to meet whatever that victim specifically needs. And sometimes it's just them checking in. Sometimes it's them calling saying, hey, this person keeps messaging me, what can you do about it? And then we could try and talk to our client about what is your purpose, how are you doing this, how do you think that's making them feel, that type of thing. Many of the probation officers that you see in the room participate in statewide initiatives or on statewide boards, whether that's the Minnesota Corrections Association, Minnesota Sex Offender Programming stuff, domestic violence stuff, all kinds of things. And so we are very lucky that our administration encourages us to take part in those statewide initiatives and be on those teams to do that stuff. So that takes some of our time. We typically try to supervise clients who live within Rice County. If they live outside of Rice County and they have what we call supervisable conditions, so something that you can actually take action on, we can transfer that client out to their resident county. If they don't have any conditions left that are supervisable or that you have to take action on, maybe they had to do a driving with care class or continue to remain law-abiding, something like that, that isn't really what they're supervisable, so we wouldn't be able to transfer them, then we keep them in. We also accept people, obviously, who are living in Rice County now, and their offense occurred outside of here. So maybe they were always a Rice County resident, and they committed an offense in a different county. We would accept supervision of that case if they meet that criteria. We already talked about making referrals to community supports, assisting in doing those client assessments whenever we can. Back to you.
Another large chunk of our day is spent as duty day agents. So all of our agents, whether we're traditional caseloads or specialized, we all have 1 day a week that we are required to be in the office. And we have to remain available for any clients who walk in. We also complete drug screens, and that could be urine samples, that could be saliva samples, or breath samples. We can collect DNA as needed or ordered by the court with our clients, assist with any client crisis or walk-in questions or phone calls that we have from either clients or other agencies and local partnerships. We also will help with bail evaluations, which was already heard earlier, if it's our duty day. I think that covers it.
So right now, we have 5 full-time traditional agents with a caseload size, average caseload size of 62 clients per agent, and that encompasses an average of 83 cases per caseload. So there are some clients who have multiple cases open, right? So that's where you get the more cases compared to your clients. So average of 62 clients and 83 cases. We have 4 people who have blended caseloads. That would be like Aaron and I that talked about earlier, how we have part of this and part of that. So there are 4 total of us that have a blended caseload. And the traditional clients on our blended caseload, our average is 42 clients and 57 cases. So it's a lot of people, it's a lot of cases, it's a lot of stuff to manage. So on the blended caseloads, if it's a blended caseload, your other part is a specialized.
All right, so hi everyone, I'm Willow Schaefer. We're going to talk to you a little bit about some specialized caseloads that we have here in Rice County, and really the purpose of these is just breaking down specific needs of our clients. So we're going to talk to you about domestic violence, Monitor Connect, sex offender specific caseloads, juvenile, and gender responsive. Sarah, do you want to start?
Yep, so my name is Sarah Lumen. I am one of the domestic violence agents within our department. There's 3 of us, myself, Aaron Langer, and Kim Hedenstrom. And these offenses, the domestic violence offenses that we supervise, are offenses involving elements of domestic abuse, involving intimate partner relationships. So these are the only cases and clients that we work with within our unit. Our average caseload size is about 45 to 60 clients. Again, you know, they may have multiple cases. One client may have multiple cases or just 1 case. And then we use a specialized risk assessment, like they were talking about down at that station. We use what's called a domestic violence risk needs assessment. And this really, again, hones in on the domestic violence aspect of these cases. In Minnesota, if you are convicted of a domestic related offense, Minnesota statute dictates that the client needs to complete domestic violence programming. And so we make referrals to various different programmings, you know, depending on the client's risk level. And that could look anywhere from like a 1-day program, a 6-week program, or a 12-week program, up to 18-week program. We work very closely with the Hope Center here in town for victim advocacy. And we also are involved with Blueprint, which is a community-based committee of stakeholders focused on victim safety. So again, contact standards are based on our risk needs level. So we can see a client anywhere from, you know, once a week up to once a month. And then we're also out doing field contacts as well, making and establishing these contacts.
I'm Kate. I have a sex offender specific caseload, and basically what that is it's all the criminal sexual conduct offenses by statute. It is the crimes that have a sexual element. So, you know, some of the pornography cases, some of the, I can't even think what else they'd be, mostly pornography cases, and failing to register as a predatory offender. So most of the sex offenders have to register in the community on something called the Predatory Offender Registry. And if they fail to register on that registry, then they can get charged with a new offense. There's 2 agents that work specifically with sex offenders. Amy is one of them, and I'm the other. Our average caseload size is probably 30 to 40 clients. And our specialized assessments, we use the level of service risk case management inventory that Sam talked about earlier. And then we also have the stable, the static, and the acute, which are specific risk assessments for that population of people. Like I said earlier, if you are convicted of a sex offense in Minnesota, most of the time you're required to register on the Predatory Offender Registry. We spend a lot of our time referring people to sex offender treatment. We spend a lot of time helping them find employment. We spend a lot of time helping them find housing, because as you can imagine, it comes with a little bit of extra difficulty given their offense and what community perception can sometimes be. As far as victim work with the sex offender, generally we are going with Melissa Evans and the Rice County Attorney's Office. Work closely with her for that. And that's pretty much what I do. Well.
And I have the pleasure of supervising a gender-responsive caseload here. I've been doing that for about 2 years, I think, along with Agent Kelly Klein, who we'll hear from later. And our goal really is to work with our clients through a trauma lens. Unfortunately, research shows that a lot of women in the criminal justice system have experienced trauma. So those caseloads were really crafted to recognize that and to work with these women and give them the specific needs that they need. So something that we take into account is a lot of our women have childcare needs, or just children in general. They need to work with us specifically to get different resources because sometimes they don't have access to those in the community. So we're really linking those resources. And we do work with like medium to high risk women on a regular basis.
We also have about 100 clients that are on a phone low-risk call-in system called Monitor Connect. They don't need to report to us in person. They call into a phone-based system and update their contact information and anything that's changed over the last month. I believe an agent will reach out to them from time to time to determine whether or not they have completed their conditions. And then we also have a juvenile caseload supervised by Agent Thurno in the back. She has a caseload of about 40 to 45 people, children, minors, and she works solely with juveniles.
What is treatment court and how does somebody get to us? So somebody gets to treatment court, either they're sentenced from it off the bat, way back at that beginning stage over there, or they come to us from a probation violation typically. Treatment court is an alternative to typically prison. So it's your high risk, high need offenders. Typically they have a prison sentence hanging over them. And it's their kind of last ditch effort. It's our last try to throw everything at them that we can with a huge wraparound service to try and help them become healthy individuals again. This is where Amy's notes would be handy for me. So how does somebody get here? They've pled guilty to a felony offense. They can be referred by either the prosecutor, the defense attorney, the probation agent, a social worker, or the client can refer themselves. They're sentenced into treatment court as a condition of probation. So they're still put on probation. They still have conditions, other conditions as well, but one of their conditions is to fully participate and successfully complete Rice County Treatment Court. Yeah, I think it's your turn.
All right. Okay, so what is the difference between treatment court and a traditional caseload? So typically when a client comes in, we have 5 phases of treatment court, and the first phase is really about acute stabilization. So getting that client the needed assessments that they require in order to address anything, whether that's mental health, typically it's substance use. It starts off with weekly contact. We'll do phone calls if they're in treatment, otherwise it's in person. We do random testing. A lot of the different conditions that we have, a lot of the different requirements we have for our participants are there because of evidence-based practices, right? So these are things that research has shown makes the client or gives the client the most success rates, or the highest success rates. Other parts of treatment courts that are different, we have daily curfew. Again, early on in first phase, it starts at 9 p.m. and by the end of it, by phase 5, they're all the way up to 11 p.m. curfew, but that's still imposed. We require them to successfully complete clinically indicated treatment. They need to stay in a safe residence. So that means they're staying in a place where the people they're living with are sober. They're not out being charged with new offenses. One of the other requirements is that they need to be able to, they have to get a sponsor. Typically that is done in phase 2 in order to get into phase 3. They have to attend a minimum of 2 meetings a week. They're going to be doing 20 hours a week of structured time, and typically that's something that'd be either work, school, treatment-related activities. That could be anything from sober meetings to treatment group to even pro-social related activities such as sober events, that sort of thing. Now, what are the actual goals of treatment court? So, number 1 is enhancing public safety. We want to ensure that our clients have extra accountability. I mean, we are, again, meeting with them once a week at a minimum early on. We're doing those curfew checks. We are making sure they're in a safe place. Another goal is to improve the efficiency and effectiveness of processing drug cases in Rice County. We want to reduce recidivism. So the recidivism is when a client reoffends. We want to lower that risk rate. I believe the statistics show it's anywhere from 7.5% to 10% is the drop in that rate based upon their participation and successful completion in treatment court. Overall, we want to reduce the social and economic costs of illegal drug activity, and we want to establish and support a pathway to success for each participant.
So currently we have our cap of treatment court people. The most we can have at this time is 25. Right now we have 16 males and 7 females. Since treatment courts started in Rice County in 2014, I believe we've had 34 or 35 graduates, commencements. I was looking at Dante over there to verify my number, if I remembered it. We're really, really fortunate that we have a really good treatment court team and a lot of people on that. So that consists of, we have a Rice County Treatment Court coordinator. We have 2 judges that sit on our treatment court, Judge Johnson and Judge Anderson, the county attorney, probation, Aaron and I, jail administrator, the behavioral health unit. Dante sits on that, and the behavioral health unit people help us a lot with treatment court by giving rides to appointments, taking them to treatment. If they're at treatment and need to get to a doctor appointment, they take them. They go with them a lot of places, and it saves us so much time. Aaron and I, we couldn't do it without them. We have social workers on our treatment team, both child protection, law enforcement, mental health therapists, public defender, and then we have our local substance use disorder treatment providers sit on there as well. So Omada, Midwest Recovery, and Fountain Centers was, hopefully they'll be back once they get somebody else in office there. This as well is a voluntary program. So they can at any point decide that they don't want to follow the strict rules and the guidelines that this has, and they can ask to have their case executed. Treatment court is not for everybody. It's hard. It's hard for them. It's hard to make some of these really big life changes, especially for people who have used substances for a really long time. And the bottom line is sometimes it just isn't the right fit for somebody. And so we do have people who are terminated from treatment court. Either the team decides that it's time for them to be terminated, or they terminate themselves. And that's okay. It's not for everybody. Part of what we do here is some of the programming that we do throughout our office that we've determined is needed based on all these risk assessments. And they're going to talk to you about that next.
All right. I'm Amy again. My name's Kelly Klein. I'm one of the probation agents here in Rice County. I supervise our gender responsive caseload, like Willow had talked to you about earlier. And Amy and I today are going to be talking to you about some of the cognitive skills program that we offer in our office as kind of an alternative intervention to help keep clients not coming through our door.
Just a show of hands, how many of you POs are trained facilitators in some kind of COG? Raise your hand. So on top of what we do every day, a lot of us have gone above and beyond to get trained in these programs to help deliver these alternate resources for our clients, specifically based on their risks and needs. So today we're going to talk to you about our women's cognitive skills group and our men's cognitive skills group and kind of how they look the same and how they look different. In addition to these two programs, throughout the years we've offered several other programs related to workforce development, financial literacy, things along those lines, but today we're going to be focusing on these two programs. So to start, just in general, a cognitive skills program really ties together the fact that our thoughts create feelings and our feelings create behavior and our behavior reinforces those thoughts. It's kind of that continuous cycle. And our job as facilitators and POs is to kind of get in and work through that thinking to help change those behavior patterns. These cognitive skills programs are ordered by the court. If they're not ordered by the court and we think our clients are applicable for them, we submit modified orders stating why we think it would be of need. Both of these programs are evidence-based, meaning there's emphasis on the fact that if and when they're presented with fidelity to the right audience, the individual's risk for recidivism or coming back through our door is going to be decreased significantly. Both of these programs are strength-based. They're very positive and uplifting. We want to focus on the individual's strengths. And they're also goal-oriented, so we're always doing that forward thinking. Both of these groups include medium to high-risk criminal justice individuals, and that comes from the assessments that have been talked about earlier. These groups are formed with attention to responsivity factors, so we look at where maybe their cognitive or educational needs or strengths lie, transportation issues, mental health, things like that. So there's a lot that goes into screening these clients before they start a program. Both of these programs approximately run for 25 weeks with about 2 to 2.5 hours given to each session per week. These programs are facilitated by trained probation officers who dedicate anywhere from 6 to 8 to 10 hours per week on top of our regular caseloads. Anything else that you can think of on my list? Okay, I'll give it to you and you can talk about Thinking for a Change.
Okay, so Thinking for a Change, as Kelly mentioned, is our male program. And like she mentioned, it's a pretty big time commitment for our clients to go through. It's about 25 weeks, but sometimes lessons can take maybe 1 or 2 sessions. So it can go out to about 30 weeks at times. They also not only meet for about 2 hours a week, but there's also homework added on top of that that they will complete. We give them opportunities to practice those skills that they're learning, so they learn it in class and then get a chance to practice it out in the real world in real life situations. And then each session will build upon the skills learned the week prior. And so part of the goal, or the goals for Thinking for a Change, are understanding connections between the thoughts, feelings, and behaviors, and to take control of thinking. So that includes like thinking before acting or not acting on impulses. Also self-reflection, engagement in pro-social interactions, and promoting personal empowerment. The curriculum for Thinking for a Change is made up of 3 areas. The first is social skills, and so that is really going to focus on how we interact with one another, and that could include like negotiating. It includes how to respond to anger appropriately, and then also how to receive feedback or give feedback to people in our lives. The second area is cognitive self-change, and what that really means is this section we spend time in examining our thoughts and behaviors and our feelings and recognizing where those risk factors pop up or where those risk feelings or risk thoughts come into play, and practice how do we not act on those. The third one is problem solving, and so that is really where we look at how to set goals, what goals to set and how do we meet them. Brainstorming different choices or options that clients might have when interacting with people in the community or family members or employers, things like that. And then also making plans for the future. And so we got some quotes from people that have graduated the program. And one of our T4C Thinking for a Change graduates said, "I picked up on a lot of skills that help diffuse certain situations in my everyday life." He continued to explain that he learned how to put boundaries in place with his family members or friends that maybe weren't as healthy for him. And it helped him learn how to listen and also give feedback appropriately. And as Kelly will talk about also, this is a huge time commitment, and so it is really difficult for our clients to work around with their work schedules and transportation and childcare at times or employment and things like that. And so it's cool when we see our graduates who might have been a little hesitant at first, when they kind of give us feedback, they have learned a lot and they use these skills in their everyday life.
Awesome. So similar to Thinking for a Change, we also offer a cognitive skills program for women. It's called Moving On. This program is designed specifically for high to medium risk women who are justice system involved. They typically come from mine, Willow, or Shelley's caseload because that's where our women fall. The goals and everything look a lot similar, but Moving On is designed more from a trauma-focused lens, kind of what Willow was talking about. So we go in knowing that the group of women that are coming in come from a background of trauma, from early onset chemical use, abuse, toxic relationships. We acknowledge that throughout the program, but the goal is to move on, to keep that forward thinking. The Moving On curriculum includes technically 6 modules, but the main ones include listening and being heard. So we talk about healthy communication skills, building healthy relationships, kind of talking about what's healthy and what's not, and how to recognize that. We also touch on some domestic related issues. Then we move on to expressing emotions, and then finally we work towards making connections and staying healthy, and that's when we really encourage the women to get involved in the community and start to use these skills. Once they've reached their graduation point, we host a nice ceremony for them. They're offered 6 weeks of aftercare to kind of keep them engaged in these skills, and then their supervising agents are encouraged to keep those skills in their everyday casework. We are running a Moving On program right now. We're on week 8 of 25. And similar to what Amy did, I spoke to one of the women, and when asked what she thought of the program, she said, "I like the presentation of the topics and the fact that we work through them as a group. I get something from it every time." She also talked about the fact that the communication skills that she's learned, the fact that she's been able to recognize some of her emotions when it comes to personal and intimate relationships have helped her build and mend some relationships in her family, which has been really big for her. And she also puts a big emphasis on her sobriety, so she gets a lot of support from the other women in the group.
So, unfortunately, we don't always, our clients don't always have the time to complete the 25 sessions for, that are required by some of these programs, or maybe they don't meet the risk level required to actually be a participant, or maybe they've already completed programming and they just need a refresher. So in those instances, we utilize these one-on-one interventions. Just to kind of give an idea of what they're based on. So majority of them are based on cognitive behavioral treatment or cognitive behavioral therapy, which can be broken down into 2 different types. So we have clinical and manualized. Clinical treatment is usually counseling led by a trained and certified counselor, and manualized treatment is an intervention led by a trained facilitator, either in a group like Moving On or Thinking for a Change, or in a one-on-one setting. Now these one-on-one interventions are, again, typically cognitive behavioral therapy based or treatment based, and they are usually worksheets, strategies that we can utilize, and we use them to address certain behaviors and case plan goals. Examples of different worksheets or strategies that we can use are thinking reports, and those are actually utilized very heavily in the Thinking for a Change program. SMART goals, and SMART stands for specific, measurable, achievable, realistic, and timely. So we want to make sure that they meet all those qualifications as we go through and kind of plan out how to achieve different things throughout their lives that they set as goals. We also do case plans, which kind of follow a very similar outline as to the SMART goals, but they can be a little bit more broad at times. We can do what I'm trained in as is carry guides or bits. And these are different interventions Typically, a lot of our clients have high-risk areas in their life, things that brought them into the system to begin with. Those are identified using our level of service case management inventory. And once we have identified those specific areas, we can actually use these tools, and they're categorized to address them specifically. And some of those areas are cognitive restructuring, criminal history, education, employment, substance use, and several others. And different tools that we can use are cognitive restructuring and reframing, journaling, thought records, activity scheduling, recognizing thinking distortions, problem solving. Now, what is the purpose? Now, these interventions usually involve efforts to change thinking patterns, as has been demonstrated to be effective for a range of problems, including not only to anger, antisocial peers, antisocial thinking, co-occurring disorders, intimate partner violence, interpersonal skills, substance abuse, motivating clients to change, reentry, etc. And each of these items that I listed have a specific tool to go along with them, with either carry guides or some of the other tools that we utilize. Now, if these tools aren't necessarily enough or we can't address all their issues with these tools, we then move on to our community partnerships, who hopefully can take it from there.
Hello, so my name is Dante Langerfeld. I'm the supervisor of the Behavioral Health Services Unit within Community Corrections Department. And I'm going to chat a little bit about community partnerships today. And really the importance of why at Community Corrections we establish and maintain partnerships throughout our community and the state. So as you can tell, many of the presenters today have already discussed collaborating with others outside of our department and how that assists clients in achieving a better quality of life. And so with that piece, it's important for us to maintain those relationships with our partners in the community because it does a couple of things. It increases communication. It can reduce wait times for our clients to be able to access those services. And it also really just helps us stay well informed and our community partners as well. So if there's needs that are arising with our clients, kind of new trends or just issues that are not getting addressed or provided for elsewhere, oftentimes our community partners then will work with us to establish those services as well. The other kind of fun and unique thing that comes out of community partnerships is the ability to create and implement new programming. And so some of those examples would be treatment court at one point came out of community collaborations or partnerships. As Shelley and Aaron mentioned, the team of treatment court really is or consists of a large variety of community partners. And without that team, treatment court doesn't work. Another one would be our community-based coordinators that we officially launched the full program last June. And our main partners with that is our local law enforcement agencies. They've allowed us to, and not only allowed us, but really welcomed us into embedding some of our staff within their departments to be able to best serve the needs of Rice County residents. We also have two new programs that are pretty exciting that were mentioned a little bit, is our police-assisted recovery and deflection and our pre-charge adult diversion programs. And those came out of a grant that Rice County was awarded, and one of the pieces of feedback that we had received was that we were awarded that grant because of the community relationships that already existed within our county. That COSAP, or it's a federal grant, they were confident that we would be able to create, develop, and implement these programs that would better assist our residents because of the relationships that existed among community partners and the county here in Rice County. Also utilizing community partnerships quite a bit is our treatment coordination, as well as talking a little bit about civil commitments. And so I'm going to pass it along to Yvette for that.
I'm Yvette Marthaler. I'm a chemical health social worker. I work in the behavioral health unit. I also work with social services. So I do treatment coordination with treatment court participants and civil commitment clients. Civil commitment clients fall under social services, so maybe we can have a walkthrough like this and I can talk about that more when we do that with social services. I guess I would just like to focus today on recovery and what recovery is. Recovery is a process of change within which one manages their health and wellness, lives a healthy and sustainable life, and moves towards reaching their full potential. So that's sort of what I use, or treatment coordination uses, to guide our work. Research, we talked a lot about evidence-based programming. So research has shown people need more than treatment, like an inpatient treatment and an outpatient treatment. They need support making a whole new life. The people we work with traditionally have severe substance use disorder. They have never lived a sober life. They don't know how to access things in a sober way, or they've never accessed things. So I do work on treatment referrals for substance use disorder. I support people getting mental health services. I support them getting medical services. I make connections with long-term services like housing, food support. I support their participation in sober activities and developing new recreational skills. I do a lot of collateral contacts with their family, trying to build sober relationships with family members and friends, and try to achieve the goal of completing treatment court or successfully completing their civil commitment.
My name is Caitlin Beaupre. I'm an intern with Rice County Community Corrections. Tori, again, from Bales. So we are here to touch on violations a little bit. So as we know in life, things don't always go to plan. When that happens, we have options how we address our clients when things don't go to plan or we have setbacks. As you can see, that does occur. In 2022, Rice County Community Corrections had 368 adult violations and 25 juvenile violations.
So kind of going off of what Caitlin's saying about it not going to plan, success is not always a straight arrow, but we do have multiple options instead of just jumping from violation to jail time. And going over some of those options is the first one being an agent directive. As was talked about in sentencing, a lot of the orders have those generalized conditions, one of them being to follow agent directives. When you're put on probation, you want to have that working relationship, and a lot of us have said the same thing. We want to work with you, not against you. So being able to give you that directive of, hey, it looks like you're struggling with some substance use. Why don't you go get a chemical assessment? That would be an agent directive. I'm letting you know this seems like an issue. Let's go get it resolved. If that is not resolved and there's a little bit of pushback, then we're moving over to a sanctions conference. That's something where the probation agent is sitting down with that client and going over a form that wouldn't necessarily mean going before a judge. They always have that opportunity, and they're kind of signing away the option to go before the court. But if they don't agree with the consequences that you are giving during that sanctions conference, or the sanctions as we like to call it, they definitely do not have to agree with it, and they can go to court in a formal violation process. But that sanctions process gives us a little ability to not have to go to court, not wait during those processing times for the attorneys, ourselves, our clients. It's kind of that instant gratification of being able to address the problem right now instead of later on. And a good thing is talking with my supervisor, being able to say, where are you going to be in 3 months? Are you going to be struggling with the same issues that maybe you're struggling with today? It's kind of hard to address something that's already happened, and maybe they've already attended treatment or gotten to be able to go to any of these programs that we've worked with to get them into. So that sanctions conference is kind of that middle, or that yellow light, as Caitlin put on here, to be able to, before we go to court. Now, a formal violation, if those two don't work and it's something where there's still that reluctancy to change and we're having issues, then we're going before the court. We're submitting a formal violation saying what actually has been violated in their terms and conditions of probation, and being able to prove that to the court. That's in front of a judge, that's with attorneys, and that's having the client be able to be there and have representation and say, I did this, I didn't do this, or what is going on, and the judge deciding what those sanctions are, instead of us just as probation agents. And that can be a lengthy process, so we want to obviously work with our clients as much as possible to not have to go through that, but ultimately that could end in jail time or any type of sanctions to help out. It could be as simple as, hey, we gave you these directives, the judge is giving the same ones once we hit that formal violation process. Maybe we go through court and it's still go get a chemical assessment, follow those recommendations.
So we have some things to consider, and it might be kind of hard to see from over there while submitting a violation. So again, that urgency, being able to assess what is happening in the now and being able to give those sanctions right away instead of waiting, again, with that court process time. If there's any risk to public safety or safety to themselves. I know a big reason a lot of us are so quick on just not going straight to the violation process is to be able to work with our clients and get them the help that they may need, because if it is substance use, obviously there's a huge issue with fentanyl right now. That is a huge risk to the public and to themselves. To be able to get into treatment instead of sitting in jail, that's obviously not our first goal. Being able to identify what else their needs are. So again, going along with all those assessments, but also reassessing. You may have a client that's low risk and then goes and gets new charges or is ending up on that jail roster that we talked about at the bail proceedings. So being able to reassess, what do they need now? Because maybe their chemical use is playing into factor and it's becoming more of an issue and maybe it wasn't before. And also just saying, what options have you tried before? Have you tried this yellow and green light situation, or did you jump right to a formal violation? What worked before? What didn't? And talking with your client too. I know being at that agent directive or the sanctions conference stage, it's way more conversation between you and your client than just jumping in front of the judge and saying, you know, my client did this, this, and this. Well, let's talk. How can we help? How can we get you these resources instead of going to jail as the last option? So being able to just identify all those things before, again, jumping to that. I know a lot of the public will think violation, jail time, there's a lot more steps than that, and we just want to be able to help our client, because again, at the end of the day, a lot of us have said it's about them being successful, it's about the community being safe, but it's also just to have them be, you know, the best people that they can be, and be a functioning, contributing member of society and not just somebody that we put behind bars. So that's not our job, and we're hoping to work well with them. But if they are already in that process and they are already incarcerated, then that's where we jump to the supervised release.
In addition to the 1,200 probationers that we supervise in our community that are court cases coming out of Rice County, there's about 9 agents in the county that supervise, part of their caseload is a supervised release. And what that is it's people coming out of prison. Minnesota uses determinate sentencing. So when you're sentenced to go to prison, you serve 2/3 in, you serve 1/3 out on paper, which is known as supervised release. Minnesota doesn't have a parole board, so you can't get out early. You don't get out early for good time. You serve your 2/3, then you come out with conditions. I think there's about 54 people on supervised release that we supervise for the state of Minnesota and the Department of Corrections. There are 6 standard conditions of probation that come out, or standard conditions of supervised release, that everybody coming out on supervised release is subject to. And those conditions are maintain contact, so they have to stay in touch with us on our schedule based on their risk needs assessment and on their level of offense. They have to submit to unannounced visits or searches. We do that anyway. They have to refrain from purchasing, possessing, accessing, or controlling any type of firearm. If you're coming out of prison, you're a felon anyway, so you can't have a firearm at this point. Remain law-abiding, so no new offenses. Refrain from engaging in any assaultive behavior, and you can't have any direct or indirect contact with anyone that's ever been deemed a victim by the Department of Corrections. The number of people on supervised release, our 2 highest cases are sex offenses, we supervise 16, and drug offenses where we supervise 16. The violation process that they just talked about on supervised release is a little bit different. There is no judge because they've been sent to prison by the judge. They are out on conditions of release set by the Department of Corrections, and if there's a violation, they go before a hearings officer that is a member of the Hearings and Release Unit from the Department of Corrections. They are provided a public defender. The Hearings and Release Officer acts as a judge, and probation gets to be probation and the prosecutor. So we present our case and all extenuating circumstances, and they have a public defender to help them with their defense. Minor release violations, they can be restructured similar to whatever it was, the sanctions conference on the yellow light over here. But it's a much faster, if they're found in violation, they go back to prison. There's not the weight between the violation and the consequence and the sentencing. So that's another big part of what we do.
Well, thank you for taking a walk with us through the journey that people experience when they come into the criminal justice system. A couple of the themes that I hope that you have consistently heard along the way is that there is a great deal of work that goes into having someone on probation, much beyond monitoring the conditions that the court imposed. Our agents spend an incredible amount of time helping people figure out how did they get to the criminal justice system, what are they going to do while they're here with us, and how can we help them to learn skills, change behaviors, change their decision-making process to help them not become a repeat person through the system. The goal of the work that we're doing is to help people stabilize their lives, build skills, be productive in the community, and reduce the risk that they're going to commit further crimes, because that's what makes our community safer, is to have people leading productive lives where they've achieved sobriety, they've been able to become employed, they're making better decisions that don't bring harm to others. And that's what creates public safety for us. So I hope you also have taken notice that, we have an incredible staff at Community Corrections. They're talented, they're knowledgeable, they're dedicated. They put a good deal of work into being able to break down the vast amount of work that they do every single day into something that could flow through for an informative presentation for you. So we appreciate you being here.